My apologies for the technical delays. For some reason, the audio driver on my computer just failed this morning. So that is working now. Shining Stars Academy versus Texas Health and Human Services Commission. If council would go ahead and make their introductions.
Yes, good morning, Your Honor. I'm Howard Klatsky. I represent the plaintiff in this case, Shining Stars Academy. With me is Lucinda Taylor. She was the owner of that facility. And I also have my legal assistant, Erin. You can't see her on the screen, but she's with me today. She's going to help me with some of the documents that we'd like to share with the court because I have horrible technology skills.
All right, thank you.
Good morning, Your Honor. Helen Kelly, Assistant Attorney General, here representing the defendant, Texas Health and Human Services Commission, of which there's a few representatives from the agency in attendance as well.
Okay. All right. And typically, I think the first thing we do is admit the administrative record, and then typically we don't take a record of the arguments and these proceedings. Is that how we want to handle things this morning?
That's agreeable.
I was going to say, I'd like to offer the administrative record into evidence.
Okay. And I know our court reporter does have that. She received it. And Mr. Klatsky, I assume there's no objection to that.
There's no objection, Your Honor. I just want to make sure that would include all of the documents that were admitted at the SOA hearing, correct?
I believe so. It should include the entire record of the proceedings, including any exhibits that were admitted during that process.
Thank you.
Yes.
Okay, great. So that is admitted. And I know Ms. Simon has a lot of transcripts that she's working on, deadline to get out. So I'm going to go ahead and let her drop off this morning, and we will proceed with the arguments.
Thank you.
Sure.
Thank you. First of all, I have to tell you, I've been practicing law now for over 30 years. I've represented a lot of facilities like Shining Stars. I've never gotten to this stage of the process, meaning I've never actually had to file a civil action. And so this is a bit unusual for me. I had some communication with opposing counsel, and it's my understanding that today, no evidence outside of the administrative record is to be presented to the court, meaning no new testimony, no new exhibits. And with that in mind, what I thought I would do is just sort of make a broad introduction to try to get the court up to speed on our position, and then walk you through what I think some of the key items are, if that's okay with you.
Yes, that's fine.
All right, well, thank you. So, Your Honor, today my client is asking the court to vacate the final order and decision that was entered by the administrative law judge, Judge Trevor Moore, in the SOA action back in April of 2022. In that action, he found that the operating permit that had been issued to the Shining Stars Academy should be revoked. We're asking today that this court set that revocation aside. We believe that the evidence and the testimony that was presented in that hearing demonstrated that the decision to revoke the operating permit was both arbitrary and capricious, and that the decision and the order of the administrative law judge was not and is not supported by substantial evidence. The evidence and testimony that was presented showed that no child attending Shining Stars was abused, neglected, or injured, that no child attending that facility was improperly punished or disciplined, that Shining Stars had successfully completed a plan of action and a corrective action according to the records of licensing, and that based upon the reported history of Shining Stars, there was other corrective action that was available to licensing that would have mitigated any risk posed to children attending that facility. We believe that the evidence and the testimony that was presented reflected an operation that was willing and able to operate in compliance with directives of licensing and the minimum standards. And like I said, I would like to walk the court through some of that evidence this morning. Now, I will tell the court in my view, the strongest argument that licensing had at the SOA hearing was simply the number of deficiencies that had been identified by various licensing representatives over the course of 2 years. I don't know if the court has had an opportunity to read the briefing that the parties have filed. It was pretty extensive. My recollection is that over the course of a 2-year period, Shining Stars received 34 deficiencies. 10 of those deficiencies were classified by licensing as being high risk. 11 were classified as being medium risk. And one of the things that we did at the hearing before the administrative law judge was present evidence that consisted solely of documents created by licensing that reflected that 2 of my clients' competing neighboring facilities had been cited for a much larger number of deficiencies for much more serious matters, and that licensing had taken no steps to revoke their operating permits. And rather than starting out with that first, that's something that I'd like to come back to, because I'd like to really start with a focus on my client. But just to give you some highlights, there was one facility that was a neighboring facility called the Handprints Academy that received 70 reported deficiencies. 23 of those were weighted by licensing as being high, and 29 were characterized by licensing as being medium high. And the deficiencies that were reported are numerous, but they included findings of placing children at risk and engaging in prohibited punishments, things that my client was never cited for. The findings of prohibited punishments that the Handprints Academy engaged in were repeated by that facility on at least 2 separate occasions, and that facility, their permit was never revoked. The second one is a neighboring facility called Aspiring Future Leaders Academy, and according to documents created by licensing, they received 91 deficiencies. 43 of those were characterized as being high, and 28 were reported as being medium high. They were cited on 4 or 5 occasions for engaging in prohibited punishments. Again, my client was never cited for that, to my recollection. Placing children in restrictive devices and other things that we can look at later. But again, that facility, unlike my client's facility, never had its operating permit revoked. I also will tell the court, licensing's apparent belief, well, let me take a step back. During the course of the hearing that we had with the administrative law judge, the argument that was being made by licensing and by its witnesses was that the person who made the decision to revoke, a lady named Amy Kidwell, I believe Miss Kidwell may be on this call, said that her decision was based upon her review of a risk analysis report that had been created by another licensing employee. Both of those witnesses testified before the administrative law judge, and they admitted they never went to the facility, Shining Stars, and they never spoke with or interviewed Lucinda Taylor. But what they argued essentially was that Miss Kidwell believed that no other corrective action would adequately address the problems, and therefore she believed that revocation was needed. Now, as I told the court a few minutes ago, before my client's permit was revoked, it was placed on one plan of action. It did so voluntarily. That was back in 2017. And according to the risk analysis report that was created by licensing, my client completed that voluntary plan of action successfully back in 2017. My client was also placed on one and only one corrective action, That was back in July of 2018. And according to the records of licensing, my client also completed that corrective action successfully. And what we argued before the administrative law judge was that if licensing felt like more enforcement action was needed, it had various remedies available. It could have placed my client on a new plan of action. It could have placed my client on a new corrective action, or it could have placed my client on probation. Ms. Kidwell acknowledged that all of those were available remedies, but none of them were chosen. And I think you picked up on this, but my client was never put on probation. They were never given that opportunity. Now, what I'd like to do, and this is where it's probably going to get a little tedious, and I apologize in advance. What I'd like to do is walk you through some of the exhibits that were admitted at the hearing relating to my client's facility. And I will start out, and it's so confusing because they were called different things at different stages of our process. I think we filed an exhibit list with the court, and we referred to it as exhibit number 5. I will tell you at the SOA hearing, it was identified as entry number 29. So Aaron, if you could please bring that up on the screen for the court. Right. And you see the exhibit sticker, feel free to ignore it. That was from a prior proceeding we had involving the same issues. Okay, but what we're looking at here is an inspection form that was created by licensing relating to an inspection that was done on March the 21st of 2017. And you probably know this, but licensing decided to revoke the permit in May of 2019. Okay, so we're going back now a little more than 2 years. And I just want to walk you through what was going on here. So if you'll, Aaron, go down just a little bit. We see that this was an unannounced investigation done on March the 21st of 2017. And if we scroll down a little further, we see that the background checks were verified by the inspector and that my client had 11 children in care at that time. Then if we go to the third page, we see the findings that were made by the licensing investigator on that date. We have one finding of compliance. We have 2 deficiency findings, and we have 1 item that is pending. Hopefully you can see that. The 2 deficiencies, the first one is that 2 non-sleeping children were not provided with an alternate activity during nap time. The second deficiency is that a caregiver was observed giving a pacifier to an infant. Those are the only deficiencies that were cited on that visit. So let's go to the next exhibit, which we have marked for this hearing as Exhibit 6. And Your Honor, this was the next visit. This is a report from a visit that was done on April the 7th of 2017 that came with the bucket seats and replaced them with belts. Okay, now that wasn't something we had been cited for on the prior visit, but that is a deficiency that we were cited for on this date. And that's actually, I think, an important one because that's one of the issues that licensing says was repeated by us, and we'll address that as we go through the documents. Then we have 2 compliance findings. Then we have a pending finding. Then if we go to the next page, we've got 1 more deficiency finding, and it says that at an inspection, the rugs were observed to be littered with debris and need to be swept or vacuumed. That was not something my client had been cited for on the prior visit. Then we have 3 compliance findings and a couple of pending items. And that's all that occurred on that date. So let's go to the next document, which we have marked as Exhibit 7. This was SOA entry number 31. This was the next document that was admitted at the hearing. It's from a visit that occurred in September of 2017. To my knowledge, no visits occurred between that last date and this date. So let's see what occurred on September the 5th of 2017. It's another unannounced investigation. If we drop down a little bit, the background checks were verified. 7 children were in care and the director was on site. Please go to the 3rd page. Here we've only got 2 items identified by licensing. One is a finding of compliance. One is a deficiency. And it says at the time of inspection, all 7 children in care were grouped in one room for nap time. This is not something my client had been cited for previously. The other thing that I wanted to point out is the things that my client had been cited for previously, it was not cited for on the date of this visit. Let's go to the next exhibit, which we marked as Exhibit 8. Judge, this was a visit that occurred the following month on October the 17th of 2017. And this is called a monitoring assessment as opposed to an unannounced investigation. If you look to the bottom of the page, we've got a deficiency finding. We haven't seen this one before. It says a person was allowed to provide direct care or have direct access to children at the operation before results were received from the FBI fingerprint check. Now, I'm happy to report nothing came out of that, but that's something we had not been cited for previously. And that's the only finding that we received on that date. The problems that we were cited for on the prior visit or on any of the prior visits were not identified on on October the 17th. Now let's go to the next document, which we've marked as Exhibit 9. Judge, this is a visit it was the next visit. It occurred on December the 5th of 2017. It's another unannounced visit. Let's scroll down toward the bottom. Go up. Background checks were verified. There were 18 children in care on that date, and the director was present. Now, if we can please flip to the 3rd page. These are the findings on that date. We have 2 deficiencies, and you're going to see these are things that we had not been found deficient for in the past. The first one is that all activity plans were available, but were not dated. I view that as a clerical issue, but it was found to be a deficiency. The next item here is during lunchtime, full slices of chicken breast was observed to be served to toddlers and older infants. According to licensing, as I understand things, that's a choking risk. That's another important issue because you're going to see it again later. But the point here is the things we had been found deficient for in the past, we weren't found deficient for on this date. That's point 1. Point 2, these 2 deficiencies are not things we had been cited for in the past. Let's go to the next exhibit, which we've marked as Exhibit 10. This was licensing's next visit to the facility. It occurred on February 13th of 2018. It was another unannounced visit. If we scroll down a little bit, we see that background checks were again verified. Lots of things were evaluated, supervision of children, child care ratio, etc. There were 15 children in care on that date, and the director was present. Now, if we flip to the 3rd page, we see 1 deficiency finding, and this is something my client had not been found deficient for in the past. The operational policies reviewed were observed to be missing a sunscreen and insect repellent policy, infant safe sleep policy, and gang-free zone notification. The points I want to make here is all of the deficiencies we saw on the other documents, including the ones from the last visit, were not found to be deficient on this visit. And the one finding here is not something my client had been found to be deficient for on any prior visits. Now let's go to Exhibit 11, which was SOA Entry 35. Your Honor, this is a report from the next visit, March 27, 2018, another unannounced visit. If we scroll down a little bit, same things. The background checks were verified, child care ratio and other things were addressed. There were 16 children in care. The director was present. If we look on page 3, and there's actually another page we're going to look at, you're going to see there were 2 deficiencies identified on this visit. The first one is the one you're looking at now, Judge. The playground was observed to have tall weeds growing thick around the perimeter of the play space. My client had not been cited for that in the past. Then let's go to the next page. Here's the second deficiency, and it has to do with training. Certainly serious and important, but the point is these two deficiencies were things we had not been cited for previously, and all of the things that we had been cited for previously were not identified as being deficient on the date of this visit. So now let's go to Exhibit 12, which was SOA entry 36. This is the next visit, June 21st of 2018. It was another unannounced visit. Background checks verified. Lots of things were looked at by licensing on that date. And there were 22 children in care that day. The director was present at the facility. Let's go to the third page, the fourth page, please. On this page, we see one deficiency finding. The floor of the hallway was found to have accumulated dirt and sand over the course of days and had not been vacuumed in a few days. And in the toddler classroom in front of the sink, a hole was observed to be in the floor. That's not something my client had ever been cited for in the past. Then we've got a compliance finding. If we go to the next page, we've got another deficiency finding. And this is additional training that was needed for the caregivers. And there were no other findings made on that date. So let's go to the next exhibit, which is our Exhibit 13. Your Honor, this is from the next visit, July 31st of 2018, another unannounced visit. Aaron, scroll down a little bit, please. The background checks were verified. Lots of things were addressed. There were 16 children in care. The director was present. If we please go to the fifth page. We have three findings. The first one has to do with the training that was needed, and you see it was found to be in compliance. Then we've got two deficiencies. The first one is that lunch service was observed. Infants and toddlers were observed to have whole pieces of chicken, lunch meat, and whole pieces of sliced bread on their plates. If you remember, I think the last one had to do with hot dogs. So that's the second time my client was identified for that issue or cited for that issue. And then the other deficiency that was identified on that date, feeding instructions for one infant who is not yet able to eat table food, were last updated on May 31 of 2018. That's not something my client had been cited for in the past. The other deficiencies that we have seen on the other inspection reports were not found to be deficient on that date. And by the way, Judge, we can flip back to it if you'd like to see it, but I will tell you, and I don't think there's any dispute about this. The person who was the acting director of our facility on the first date that a finding was made about uncut hot dogs being served was not our director on the date of this visit. We had a different director working at the facility on this day. The point I'm making is when we had a particular director working at a facility, that director was only cited for serving uncut up hot dogs or uncut up chicken once. So let's go to the next exhibit, which is Plaintiff's Exhibit 14, SOA entry 38. This was the next inspection. It was done on November the 6th of 2018. It was an unannounced visit. Background checks were verified, and there were 29 children in care. The director was present. Let's go to the fourth page, please. Now, on this date, you see we have two pending issues, and then we have one deficiency finding, and it's one that we have not seen before. It says that hazards were found present at the operation. There were cleaning supplies kept low and in reach of children, and a toy bike that was broken, leaving sharp edges exposed. The other deficiency findings that we've looked at today were not found to be deficient on this date. And this issue about the cleaning supplies and the bike was not something that my client had been found to be deficient for in the past. Let's go to Exhibit 15, which is SOA entry 39. This was the next visit, February 8th of 2019, another unannounced visit. Background checks were verified, various issues were examined, 25 children were in care. The director was present. Let's go to the fourth page. There's a second page to this document that we're going to look at, but here's the first page of the findings. One issue having to do with child care ratios, which my client has not been cited for in any of the documents that we've looked at, is listed as pending. Then we have a deficiency. A rug needs to be cleaned and sinks in the restrooms need to be cleaned. And then we've got something about hand soap and a toy sitting in the mop sink. Then we have another issue here about policies for release of children. We haven't seen that before. It was shown as pending. If we go to the next page, we do have some deficiency findings, so we need to look at those. The first one is carpet in the preschool classroom was in disrepair and posed a tripping hazard. And then something about a rolling food cart. It was stored in the toddler classroom. The next deficiency is that the inspection menus were rotated. No record was available indicating which menu was for each day. Next one, a caregiver did not know group responsible for. That's not something we've been cited for in the past. Then it says during an inspection, children were observed using chairs equipped with manufacturer safety straps. The straps were not fastened while the chairs were being used. That's the second time we've been cited for that. I will tell you, and if you'd like, we could jump back and show you a different director was in charge of the facility on each of those occasions. Then if you look at the next deficiency, it has to do with the background checks needing to be done. Those are the only findings that were made on that visit. So let's go to our exhibit number 16. And Judge, we're almost through these. This was SOA entry 40. This was another unannounced visit. And it was made on February the 20th of 2019, which is 12 days after the last visit took place. It was an unannounced visit. Background checks were done. Lots of issues were examined. 29 children were in care, and the director was present. Let's go to the fourth page. We see some pending matters, and then we see 3 deficiencies noted on this page. The first one, the first aid kit was incomplete. My client had not been cited for that in the past. The second one, a food allergy emergency plan, was not signed by a parent and a healthcare professional. That's not something we had been cited for either. The next one, during an inspection, a caregiver did not have infant training. That's not something we had been cited for in the past. Go to the next page, please. There are 3 more items here at the top. Deficiencies. The first one, during an inspection, it was found no fire drill was conducted the previous month. We had not been cited for that in the past. Next one, during an inspection, several nap mats were torn, foam was exposed. Then the last one that we're looking at here, during an inspection, a copy of the most recent licensing investigation was not posted as required. Then if we look at the bottom, it says, right there, it says, the following standards were cited during a previous inspection. The finding column below states whether the previous deficiencies were corrected. As for the straps on the chairs, it says deficient. As for the carpet and the tripping hazard, that was found to be in compliance. Then if we look at the last page, let's see this one here. It has to do with background checks, was deficient. Then we have 2 compliance findings. One had to do with the menus that were not appropriately dated. That was found to be in compliance. And then the other one was the caregivers knowing which groups they were responsible for. That was also found to be in compliance. Now let's go to Plaintiff's Exhibit 17, which is SOA entry 41. This visit took place on February 18th, so I think that was 8 days later. It was an unannounced visit. Background checks were verified. Lots of issues were examined. 23 children were in care. The director was present. If we look at the fourth page, we've got some issues that licensing identifies as pending. Then we've got 3 deficiencies cited. The first one, space between the gates of the fence on the playground poses a hazard. Well, we never had a child get out of the facility. We were never cited for this in the past, but it's notable, and we'll see if it was identified in any other reports. The next deficiency, it was found that there were not enough popular items available, so children were not forced to compete for them. We had not been cited for that before. Then we've got the third deficiency finding on this page. During an inspection, children younger than 4 were observed served whole wieners. That's the third time we've been cited for that. But again, that's a different director. I'll be happy to show you that if you'd like me to. I think opposing counsel acknowledges that I'm correct about that. The point I'm making here is that's an important issue. But when we had a director in place at the facility over the course of 2 years, no director was cited for being deficient for doing that more than once. Now, if we look at the next page from that same visit, you see 5 compliance findings that were made by the inspector on that date. Look at the top of that page. The rugs had been cleaned. The sinks were clean. The mop sink was clean. The next item, infant training had been completed by the caregiver. The next one, the fire drill was completed and documented. Next one, the inspection, licensing, most recent inspection form was posted. And then the last one, the infants were observed to be strapped with manufacturer safety straps while using infant equipment. So there, 8 days after we were found deficient for the child care straps, when licensing came back on an unannounced visit, they found that had been corrected. So let's now go to Exhibit 18. This was SOA entry 42. This is from a visit that was done on March 11 of 2019. Remember, Judge, it was in May of this year that licensing decided they had to close the facility. So on March 11th, let's see what happens. This is an unannounced visit. We didn't know they were coming. Background checks were verified. We had 21 children in care. The director was present. So let's see what the inspector found. That's the 4th page. Only 2 findings were reported, both in compliance. No deficiency findings were made by licensing inspectors on that date. You see, it says that it was determined that a child in care was not medically diagnosed with a food allergy. And then the other one is no children younger than 4 were being served food that posed a choking hazard. So let's go to the next inspection, which was our Exhibit 31, SOA entry 43. All right, Your Honor, this is from the next inspection. It was done on April the 2nd, about a month before licensing felt the need to shut us down. It was an unannounced visit. So again, we did not know they were coming. Background checks verified, lots of issues were examined, 25 children in care, and the director was present. So let's look at the 4th page and see what was found on that day. One deficiency, and let's look at what it was. A television was observed being used with children in care, and the TV was sitting on a table, not anchored. That's the only deficiency finding made on that date. We had never been cited for that before. And then look at the other findings that were made. Let me read this. It says the following standards were cited during a previous inspection. The findings column below states whether the previous deficiencies were corrected. And there are 2, and they were both corrected. The first one had to do with the nap mats, and then the next one had to do with popular items being made available for children. No other deficiency findings were made. 2 compliance findings were made on that date. Let's go to the next document. Hopefully we've got it. It was our Exhibit 20. This was the last inspection that was done by licensing before they felt the need to shut us down and revoke our permit. It was conducted on April the 10th of 2019. It was another unannounced visit. Background checks were verified. Lots of issues were examined. 28 children were in care, and the director was present. So let's go to the 4th page. You see here, no findings of deficiency were made. There were some things that were pending, but no decisions had been made yet. And 1 compliance finding was made, and look at what it was. The television was removed from the facility. If you remember from the last visit, we were cited because the TV had not been anchored. Well, here a few days later, they show up unannounced and found we had removed the TV from the facility. We were found to be in compliance. No other deficiency findings were made. And that's it. That's it for the investigations. After this occurred, licensing felt the need to close our facility. Now, there was another document that I wanted to share with you, if I can find it here quickly. We've identified it as Exhibit 6. Your Honor, this is a document that was admitted at the SOA hearing that I wanted to share with you. You will recall that over the course of 2 years, we had 3 different directors present at the facility. Each director was cited once for serving uncut food to the children. And the argument that licensing has been making is that we had repeated deficiencies. One of them is serving uncut food. So this is an email that Cindy Taylor, that's Lucinda Taylor, sent to the licensing representative. Scroll down so we can see the date. In February of 2019. So now go back up to the top. Let's look at it. It says, Miss Jackson, I have an issue regarding choking hazards. What is your requirement for serving bologna, chopped ham, turkey, and chicken lunch meat, and sliced blocks of cheese? Do any of these have to be cut up? Does bread have to be cut up? Do canned sliced pears and peaches or pineapples have to be cut up? We were cutting all of these up before then. Miss Johnson and Miss Pender said these items do not have to be cut up because the kids can pick these up and eat them. We were spending too much time in the kitchen, according to these ladies. Thank you. This was an email that my client sent to licensing, specifically asking for help and guidance to address these deficiencies that she was receiving for this particular issue. The reason why I think this is an important exhibit is because to hear licensing make its case, this was a reckless, dangerous facility that was placing children at risk and did not care about what licensing wanted. And this is an example of our owner taking affirmative steps months before licensing decided to shut the facility down to comply with the minimum standards and prevent more deficiencies like this from taking place. Okay, we can take that exhibit off of the screen. Now, Your Honor, I would like to show you a few other documents. Okay, Your Honor, you'll recall when we began today, one of the arguments I was making was that we feel like the decision made by the administrative law judge and by licensing is arbitrary and capricious because let me take a quick step back. In my experience, when facilities are shut down by licensing and permits are revoked, we see reports where children have been injured, they've escaped the premises and they're wandering on a street, things like that. We didn't see anything like that with these visits. No child was injured. No child escaped. No child was harmed. No child got sick. I mean, you're not going to find any of that in the reports that were created about shining stars. But the argument that licensing has been making is, yeah, but this facility had so many deficiencies, they're not going to listen to us. We've got to shut it down. Well, here's an example of a facility that has not been shut down. And this was marked as SOA entry 46 when we presented this to the ALJ. These are reports from a neighboring facility of my clients called Handprints Childcare. And if we look, and there's going to be, let's go to page 2. You see there, during the last 5 years, 70 deficiencies were cited. 23 were weighted as high. 23 were weighted as medium high. If you'll go back a couple of pages. There we go, drop toward the bottom. All right, Judge, this is a little bit hard to read, and I apologize. But if you look at the second to last, well, we've got a bunch of things here. And they're the types of things that we see when we look at the records that were created for my client. Fire extinguisher issues, posting requirements, parent signatures needed on a health statement. Let's go back a few more pages. All right, Your Honor, here's one of the ones that stands out to me. If you'll, there's a lot of things going on here. The first one has to do with the maintenance and the grounds of the building, issues with surfacing. But if you look at the fourth item, we've got prohibited punishments using harsh, abusive, or profane language. That occurred, or at least was cited on June 5 of 2019. Hopefully you can see that. Then if you drop down 3 more, they were cited for responsibilities of caregivers, knowing group responsible for, just like my client was. And then below that, they were cited on October the 24th of 2018 for prohibited punishments, using inappropriate long period of silence or inactivity, including requiring a child to remain in a restrictive device. Then drop towards, go back like 10 or 15 pages. Right, Your Honor, there's a few things here I wanted to show you. There, you see this facility was cited for having an activity plan that didn't include group names and dates. Feeding instructions weren't appropriate. Policies did not comply with the rules. And then look at the next one. Reporting a situation, placing child at risk. They were cited for that. And then the next one says responsibilities of employees and caregivers. Demonstrate competency, good judgment, and self-control. The facility is being cited for those things. And then there's one more document on this exhibit, which is toward the very back. The date we're looking for is May 22nd, 2017. All right, Your Honor, this here we've got a couple of things that I wanted to highlight for you. The first one is the annual fire inspection. Just like us, they were cited for that. Next one, individual crib for each infant. They were written up for that. Requirements for feeding infants. Prohibited punishments using harsh, abusive, or profane language. They were written up for that back in 2016. Next one, the floors, the ceilings, and the walls were not in good repair. Immunization records, and then safety, area free from hazards. This facility had all of these deficiencies. They weren't cited. My client was never cited for prohibited punishment. This facility is smacking children on their hands and doing these other things. Now, you know, licensing argument is, well, that's a larger facility. It's not relevant. But my point is, it's a neighboring competing facility of my client. So it's relevant to my client. And assuming that it's a larger facility with more children, they would have more caregivers to look after the children. I mean, I respectfully submit that if I shared these facts with you and said, pick one facility to send your child to, most reasonable people would want the facility that has not been written up for repeatedly for engaging in prohibited punishments and placing children at risk. Shining Stars was never written up for that. Now, there's one other facility that I wanted to talk to you about briefly, and it was entry number 47 at the SOA hearing.
You've reached 50 minutes, just so you know where, as far as time goes.
I appreciate that, Your Honor. And I'm sorry, I know this is tedious, but you know, I'm trying to get you up to speed with a lot of information in a very short amount of time. So, Your Honor, these are records we got from Child Care Licensing. This is for another neighboring competing facility. This one is called Aspiring Future Leaders Academy. If we look at the second page of this exhibit, we see that this facility was written up for having 91 deficiencies. 43 were weighted as high, 28 were weighted as medium high. Go back about 2 pages, please. Okay, right there. And these are records referencing visits made by licensing to this facility. The first entry, May 10th of 2021, prohibited punishments were cited for using harsh, cruel, or unusual punishment. Then we've got some cleanliness issues, responsibilities of caregivers and supervision of children, and child care ratio. They were also written up on August the 20th for not having appropriate feeding instructions. They were also written up for not having appropriate background checks. If we go to the next page, this has the same write-up on May 10th for prohibited punishments. But if you look down toward the bottom on September the 17th, the second entry, again, prohibited punishments. That was on 9/17 of 2019, again, for harsh, cruel, and unusual punishment. Then let's go several pages back. The date we're looking at is August the 23rd of 2019. Same facility, back on August the 23rd of 2019, they were written up for prohibited punishments using harsh, cruel, or unusual punishment. On July 17th, they were written up for prohibited punishments using harsh, abusive, or profane language. On July 2nd of 2019, they were written up for serving food that presented a choking risk. Now let's go to page dated July 2nd of 2019. Yeah. Okay, Your Honor, same facility, July 2nd of 2019. You see they are written up for improper supervision of children, not demonstrating competency, good judgment, or self-control. On June 28th of 2019, they were cited for placing a child at risk. June 25th, caregiver didn't know what group he or she was responsible for. One day earlier, they were cited for improper supervision of children. On that same day, they were cited for not demonstrating competency, good judgment, or self-control. And on June 24th, that same day, they did not report a situation where a child was placed at risk. Now drop down several pages. We're looking for the date of January 31st of 2019. All right, Your Honor, here we're looking at what occurred on January the 22nd of 2019. The first one is that, again, a caregiver didn't know what group they were responsible for. And then if you look on January the 22nd of 2019, again, they were written up for engaging in prohibited punishments, using harsh, cruel, or unusual punishments. Back on November 20th of 2018, they were cited for not ensuring that a child was not abused, neglected, or exploited. On October the 12th of 2018, again, cited for engaging in prohibited punishments. No harsh, cruel, or unusual punishments. And on June 7th of 2018, they were cited because they had a child sleeping in a restrictive device. Then we've got a couple more I want to share with you. This one is dated April 30th of 2018. So Judge, on April 30th of 2018, that same facility, again, cited for engaging in prohibited punishments, hitting with a hand or an instrument. In November 14th of 2017, a caregiver did not know what group he or she was responsible for. And on June 15th of 2017, a caregiver did not have current training in first aid. Now drop back a few pages. Here in August and July, August of 2020, improper feeding instructions, problems with children's records being maintained properly. Then if you look in July of 2019, we have problems with parental notification about injuries and issues with nutrition and food service. If you go to the next page, on June 28th of that year, they were written up for placing a child at risk. This is in 2018 and 2017. The facility was written up for situations placing child at risk, improper pre-service training about supervision and safety, improper feeding instructions. Then if you go, let me see if here, find this page toward the back. The date is November 23rd, 2020. Nope. Oh, it might be on the next page. That's okay. We can stop. Your Honor, I took your time and I appreciate your patience walking you through those things. I've now shown you two facilities that are in the same geographic area that my client was competing with for business. According to licensing's own records, those facilities were being found deficient repeatedly for the same types of things and for much more serious behavior that really do place children at risk. Their licenses were not revoked. My client's license was revoked. And the point that I really want to make when I walked you through all the reports from my client's visits, meaning the visits that took place at my client's facility, if this was the type of a facility that was not willing to comply with minimum standards, you would have found the same deficiencies visit after visit after visit. And hopefully you'll recall that when we walked through those documents, that was rarely the case. On virtually every occasion, a deficiency or two was found. A visit was made a few weeks later. The same deficiencies were not found to be in existence. If my client's facility did not care about complying with minimum standards or was not able to do so, you would not have seen compliance findings that were identified visit after visit after visit. And in terms of timing, the decision that licensing felt the need to make in May of 2019 does not make what my father used to call walking around sense. Where was the harm? Where was the immediate danger? What was happening in March and in April of 2019 that convinced the decision makers at licensing that this facility had to be shut down now? I showed you in March, there were no deficiencies. And we know we were on their radar screen. And they didn't tell us they were coming. In April, there was one deficiency finding, and it was something we had never been cited for in the past. It was for having an unanchored TV. They come back a few days later, and that TV had been taken out of the facility, and we were found to be in compliance. So the timing of this decision literally makes no sense. Now, the only other point that I wanted to make to the court, and this is not something you've heard me talk about yet, has to do with the decision-making and the factors that the decision maker at licensing testified about at the SOA hearing. What she told the court, and I'm talking about Ms. Kidwell, was that when she made the decision to revoke the license, she considered 6 factors that are included in section 745.8607 of the administrative code. And I can walk you through them all if you'd like me to, but the problem that I've got with her testimony, and the reason why I think her decision-making was not reasonable, is because if you take the time to look at that code, there are 8 factors that are supposed to be considered, not 6. And if you look at that code and it lists the 8 factors, it lists 7, and then it says and it lists the 8th. It doesn't say or. Licensing argument is she doesn't have to consider all 8. My argument, and I feel like general construction of the statute supports it, is the statute says and, not or. I mean, if I tell the court that Ms. Kelly and I are participating in this hearing, I suspect that means you're going to expect us both to participate. If I tell the court that either myself or Ms. Kelly will participate, you're probably thinking, well, one or both of us might. The statute is very clear. There are 8 factors that have to be considered when licensing is deciding what type of enforcement action to impose upon a facility. And according to the testimony given by Ms. Kidwell at the hearing, she only considered 6. There are 2 factors that she did not consider. One of them is the 3rd factor, which is whether the deficiency can be corrected. The 2nd factor that she did not consider is how quickly the correction can be made. And I respectfully submit that if she would have taken those additional factors into consideration, the finding should have been different. Because I've shown you visit after visit, time after time, that when we would be written up for something and they would come back a couple of weeks or a month later, on virtually every occasion, the same deficiency had been corrected. With the television, they came back literally days later and the TV had been removed from the facility. Now, Judge, I'm going to wrap up with this, and I don't know if I also get the last word, probably not, but let me just conclude with a couple of comments. First of all, Lucinda Taylor has been in this business for over 40 years. If you'd like to hear from her, she'll be happy to speak with you. She cares deeply about her business and about this profession. She's passionate about it. We are not disputing the fact that a number of deficiency findings were made. I think I told you at the beginning of my argument that there were around 34 deficiencies cited over a period of 2 years. We acknowledge that. And I'm not trying to argue that some type of enforcement action would not have been appropriate. If licensing felt the need to place them on a new plan of action, that would have been acceptable. If licensing thought something more serious was needed, like a corrective action, that would have been acceptable. Even if licensing felt like probation was needed, that would have been acceptable. But my client was not given any of those options. Now, licensing may argue, well, they weren't given those options because it wouldn't have done any good. But the evidence and the testimony that was presented at the SOA hearing defeats that argument. Think about it. Back in 2017, my client was placed on one plan of action, and according to licensing own records, completed it successfully. According to licensing's own records, my client was only placed on one corrective action. That was back in the summer of 2018, and it completed it successfully. It was never placed on a corrective action in 2019. So you've got a facility that complied with the only plan of action that it was placed on, that complied with the only corrective action that it was placed on. How can you say with confidence, well, if we try it again, they're not going to listen? There's no support for that at all in the administrative record. And how can you reasonably say that, well, probation won't work either? They had never tried that. My client was never placed on probation. Those are the types of things that we're looking at. And what I submit to the court is when you have a facility that receives deficiency findings and then has unannounced visits take place and is found to be largely compliant, when you are looking at a facility that is placed on a plan of action and completes it successfully, placed on a corrective action and completes it successfully, and are looking at a facility that has never had a child lost or injured or abused, those are the types of facilities that we want operating. Those are not the types of facilities that need to be shut down on an emergency basis, which is exactly what occurred here. Now, Your Honor, I know I've been very long-winded and I apologize. But at the end of the day, we respectfully ask that you take this evidence and these arguments into consideration and find that the revocation was too severe. I mean, that in our world, that's like a death penalty sanction. We ask that you revoke the decision, that you set aside the decision that was made to revoke the operating permit. And my client and I thank you very much for your patience and for your time.
All right. Thank you, counsel. And Ms. Kelly, you may respond.
Thank you, Your Honor. I apologize for my voice. As I say, my son is actually in daycare, and so he's bringing home every known disease. The Texas Health and Human Services Commission requests that the court affirm the commission's final decision revoking plaintiff's permit to operate a child care facility because it is supported by substantial evidence and is not otherwise affected by an error of law. Shining Stars Academy has the burden to show the commission's order revoking its permit to operate a child care facility is not supported by substantial evidence. Under the substantial evidence standard of review, it is Shining Stars Academy's burden to present evidence sufficient to overcome the presumption that the commission's decision is valid and supported by substantial evidence. Only more than a mere scintilla of evidence is needed to uphold the commission's order. The substantial evidence standard does not permit the reviewing court to reweigh the evidence and substitutes its judgment for the judgment of the commission. Instead, the reviewing court must determine whether some reasonable basis exists in the record for the commission's action. The reviewing court may affirm the commission's decision on any grounds that would support the decision and is not bound by the reasons given by the commission in its order. Based on the evidence as a whole, if reasonable minds could have reached the same conclusion as the commission, then the commission's decision is supported by substantial evidence. Shining Stars Academy has not met that burden because the evidence in the record shows that the child care facility had numerous deficiencies, many of which were considered to be a high risk to children's health and safety. Moreover, despite being voluntarily put on a plan of action and then later put on a corrective action plan, many of the deficiencies were repeated. A risk assessment revealed that Shining Stars Academy posed an unacceptable level of risk. The commission staff evaluated Shining Stars and determined that despite all the extra assistance that had been offered, that there was no other corrective action that would mitigate the risk to children other than revocation. The evidence in the record supports the commission's decision to revoke. I will briefly go through some evidence in the record since opposing counsel laid so much of it out already. Shining Stars was issued a permit on February 8th of 2016. Less than a year after being issued a permit, Shining Stars Academy entered into a voluntary plan of action for deficiencies, including failing to obtain background check results before allowing unsupervised contact with children and failing to maintain child-to-child caregiver ratios. due to ongoing deficiencies, including failing to obtain background check results before allowing unsupervised contact with children, and ensuring that children were not served food that presents a choking hazard, Shining Stars Academy was placed on a corrective action plan. Despite these 2 attempts at remediation, subsequent inspections revealed numerous deficiencies between November of 2018 and April of 2019. Again, including failing to obtain background check results and ensuring that children were not served food that presents a choking hazard and failing to utilize safety straps. A risk analysis was conducted that covered the time period from April 5th of 2017 to April 5th of 2019. During that time, there were a total of 32 deficiencies. Of those 32 deficiencies, 10 were classified as high risk, 11 were classified as medium risk, and 11 were classified as medium risk. Failing to obtain initial background checks for caregivers and serving food that presents a choking hazard to children are both considered to be high-risk deficiencies. Similar-sized operations averaged 7 deficiencies, with 5 of the 7 deficiencies being categorized as high or medium-high risk over the same period. So Shining Stars Academy had significantly more deficiencies. In fact, they had over 4.5 times the number of deficiencies that similarly sized operations would have had. While Shining Stars claims that it was treated harsher than its peers, that's really not supported by the evidence in the record. The facilities that Shining Stars is comparing itself to are significantly larger, and the fact that Shining Stars concedes on page 17 of its brief. The maximum capacity of children that Shining Stars facility could hold was 34. The facilities that it cites to had capacities of 250 or more children. So I believe opposing counsel brought up aspiring leaders, and they had about 91 deficiencies. Shining Stars had over 30. So, though they're significantly smaller, about seven times smaller, they had almost a third of as many violations. So if they had been a larger facility, I'm sure they would have had more violations than the facilities that they're attempting to compare themselves to. And also of note, there was much made about the high harm of prohibited hitting or language being used with children. Those are high risk. Those are unacceptable. Those are not in compliance with the minimum standards. But so is the fact of not having background checks or exposing children, sometimes even infants, to food that they could choke on. Both pose dangers to the life and the health and the safety of children. Other issues that Shining Stars has brought up is that the deficiencies that was cited for fall into a cleanliness or a documentation issue. So even if we were to ignore those issues, there's still several serious deficiencies. And just briefly, the safety straps, Shining Stars was cited on April 7th of 2017 and again on February 8th of 2019. Shining Stars was cited for background checks, three background checks on October 17th of 2017, but again on February 8th of 2019. On 3 occasions, it was cited for serving food that presented a choking hazard on December 5th of 2017, July 31st of 2018, and February 28th of 2019. Other issues related to safety include the broken bike with sharp edges and the low cleaning supplies, the unsigned food allergy plan, failing to conduct a fire drill in the previous month, and having the gap in the outdoor gate. On 3 occasions, Shining Stars Academy was cited for needing additional caregiving training. Shining Stars attempts to minimize its responsibility by pointing out that there were 3 different directors during this time period, but Shining Stars is the facility that was issued a permit to operate the childcare licensing facility. Therefore, it is its responsibility to make sure that its directors, its employees understand, know, and comply with the Commission's minimum standards for taking care of children in its care. So the fact that, something may have happened under one director and they got rid of that director by firing or terminating, whatever the case may be, doesn't really absolve them of the responsibility, because they didn't bring in someone that was trained, because the same issues were repeated again and again under each of its directors. So Shining Stars failed to make sure that there was someone in that position with the knowledge and experience to make sure that the same minimum standards were not being violated. It doesn't do any good to have gotten rid of one director if you just bring in someone else who is still not going to comply with the minimum standards. Next, Shining Stars talks about not all of the factors being considered. Specifically, Shining Stars contends that 2 statutorily required factors must be considered. If we look at the Commission's Rule 745.8607, it says that the Commission decides to recommend or impose enforcement actions based on our assessment of the following. And there's 8 factors listed. However, these factors are not required to have an individual finding made out of each one to be written down somehow. And so when you consider 1, the severity of the deficiency, 2, whether the deficiency has been repeated, 3, whether it can be corrected, 4, how quickly the correction can be made, 5, whether you demonstrate the responsibility and ability to maintain compliance with the minimum standards, 6, whether the conditions imposed to avoid further deficiencies, 7, your compliance history, and 8, the degree or immediacy of danger or threat posed to the health and safety of children. Some of these factors will be more or less applicable depending upon the deficiency. And some of them are so interrelated, whether it can be corrected at all. If it can't be corrected at all, well, how does it matter how quickly the correction can be made? And even if it has been corrected, if you can't maintain that correction, then, I don't know that necessarily going through each specific factor and making a finding when some of them necessarily implicate the other factors. So I think Shining Star specifically claims that factors 3 and 4, whether the deficiency can be corrected, and 4, how quickly the correction can be made, were not considered. Those are present in the other factors, specifically, whether they can maintain that compliance. And the HHCSC staff that participated in the SOA hearing testified that Shining Stars Academy was able to be compliant while they were being constantly monitored, whether it was on the voluntary plan of action or the other plan. But once they stopped doing those plans, they kind of went back. They reverted back to violating the minimum standards. And so when Shining Stars says, why didn't you just put us on probation? The Commission doesn't have infinite resources to constantly monitor, its permit holders. They can't constantly be standing over Shining Stars Academy and making sure that they comply with the minimum standards. At some point, Shining Stars needs to comply, or if they're unable to do that, the Commission, can't keep devoting resources to a facility that isn't ever going to be able, in their determination, to comply. So while Shining Stars would have liked to have seen some other punishment, they're not entitled to endless opportunities to meet the Commission standards. Or I think as someone testified at the SOA hearing, the Commission doesn't have to wait until there's an unfortunate incident where a child is injured or harmed before they can step in to take action. So the Commission isn't required to exhaust all available enforcement remedies. The Commission has a rule 745.8654. They talk about using the assessment criteria in 745.8607 to determine, whether your operation is eligible for corrective action or whether they should be placed on probation or suspension, whether there's a finding of abuse or neglect that makes you ineligible for a permit, or whether revocation is otherwise necessary to address the issues identified. There's no mandatory language. There's no use of the word must or shall. So HHSC isn't required to put a permit holder on corrective action just because it's their first violation, nor are they required to put someone on probation because it's their third violation. This isn't baseball. It's not 3 strikes and you're out. And it's been well established that agencies have broad discretion to determine the appropriate sanction when there's a violation of their statute or rules. And the fact that there's been 32 deficiencies, no one's contesting those. Those are undisputed. And the fact that 10 of those were high risk, 11 were medium to high risk, and 11 were classified as medium risk is more than enough substantial evidence to support the commission's action. At the hearing, there were several factors identified that supported HHSC's action, including serious deficiencies in minimum standards, several deficiencies that created an endangering situation, a pattern of deficiencies, and immediate threat to the danger of the health and safety of children. And specifically, the background check issues and the choking on food issues were cited, as well as all of the health and safety practices. So under Rule 745.8654, revocation was deemed to be necessary due to the issues identified. In conclusion, Shining Stars Academy asked the court to overturn the final decision and order and vacate and set aside the defendant's revocation. But none of these actions are relief that the court may grant under the substantial evidence standard of review, which is located in the Texas Government Code, Section 2001.174. The court may affirm, reverse, or remand. The commission respectfully asks the court to affirm the commission's final order because it is supported by substantial evidence and not affected by an error in law.
All right. Thank you, counsel. Mr. Klatsky, you may have the final word if there's anything else that needs to be said. I do plan on taking this matter under advisement so that I'll have additional time. I would say I have made an initial review of the record, but I generally do take a look after I've heard arguments of counsel.
Thank you. I'm going to be very brief since I spoke so much earlier. We're asking for either a reversal or a remand, Your Honor, and we believe that when you have the opportunity to go back and review everything that's been submitted, that you will think that one of those options is appropriate. Just a couple of quick things. During the course of the SOA hearing, the decision maker of licensing admitted that my client was eligible for corrective action and that my client was eligible for probation. But they decided not to go with either one of those options. And then the other point, and I think you've heard me say this, the argument that counsel makes, and she's done a great job. She's a very good lawyer, and we work well together. But if you look at that statute that I cited to the court, it's very clear that when a decision about what enforcement action to take is to be made, 8 factors are to be considered, not 1, not 2, not 3. Now, 1 might be enough, but at a minimum, the decision maker is required by statute to consider all of them. And in a very, almost like a did you order the code red moment, if you remember that movie with Tom Cruise, we actually had the decision maker admit under oath, I only considered some of the factors. And respectfully, any decision made by licensing that failed to consider mandatory factors is not reasonable and would be arbitrary and capricious. And in terms of, I told you counsel was going to argue this, they don't want the court to think about how the other facilities were treated. But those facilities are the ones that my client was competing with. They're in the same geographic area. And yeah, they have more children to care for. They also have more caregivers. But at the end of the day, Your Honor, we're hoping that when you go back and look at the history, the reported history of Shining Stars, what were they cited for? Did they correct the problems? Did they remain deficient? If so, for how long? I think the court is going to say, this facility was, it had quite a few deficiencies, but it usually responded. and it clearly respected the minimum standards and made attempts to abide by them. And when we consider the other facilities that are out there and the fact that we all want our children to be in a safe environment, nothing about this facility warranted immediate closure or license revocation. Please, I would ask you, Judge, ask yourself, okay, they shut it down in May of 2019. What was going on there in March and April that was so bad? I mean, I would think we would see horrible findings, but they're not. In fact, it's completely the opposite. And to me, when you've got a facility that hasn't been hit with any significant findings 2 months leading up to closure, but yet you still decide closure without ever giving them a chance to even serve time on probation, that's arbitrary and capricious, and it's not reasonable. So we thank you again for your time.
Okay. All right. Thank you, counsel. I don't have any questions for you. I think, thank you for your presentation and your arguments. It may be several weeks before you hear back, but when a decision has been made, you will probably receive an email or a letter ruling from court staff.
Thank you so much.